morning. My name is Blair Fitzsimmons. I'm the Executive Director of the Texas Agricultural Land Trust, and I have with me today Steve Small joining us from Boston and Joseph Fitzsimmons joining us from San Antonio. I'd like to welcome everybody. We have about 100 participants registered from all over the country. I would like to point out, though, that this webinar is geared for Texas landowners, although there will be plenty of information, I think, relevant for everybody attending. The presentation will last about 30 minutes, and then we'll have a Q&A session following that. Before we start, though, I'd like to go over some pointers on how to participate. By clicking the orange arrow, you can open and control your panel. From the View menu, you can also set the control panel not to auto-hide when inactive if you prefer to keep it always open. The audio pane provides audio information. Click the audio setup to select your computer speaker or headset devices. If you prefer, you can join the audio via telephone by selecting Use Telephone, and the dial-in information will be displayed, including an audio pin. If you would like to ask questions of today's presenters over the phone, you must enter your audio pin in order to have your line unmuted. During the presentation, you have the ability to send questions to our webinar staff through the Questions pane. Simply type in your question and click Send. At the end of the presentation, as I said, we will do a Q&A session to answer as many questions as we have time for. During the presentation, we may ask you to answer a question by raising your hand. This option is located on the Grab tab. You can also indicate that you have a question and would like your line unmuted by raising your hand. We will address the Q&A at the end of today's session. As a final reminder, today's webinar is being recorded, and everyone will receive an email within 24 hours with a link to view a recording of today's event. Up in the right-hand corner of the slides, you also have a tech support number if anybody has any problems. Feel free to call that number, or you also have my email, and you can shoot me a quick email, and we'll try to troubleshoot from this end. First, real quickly about the Texas Agricultural Land Trust. We are a relatively new land trust in Texas. Our mission is to protect agricultural lands, working lands, and we have partnered with landowners to conserve almost 100,000 acres in Texas since 2007. We were created by leaders from 3 statewide organizations, the Texas Wildlife Association, Texas Southwestern Cattle Raisers Association, and Texas Farm Bureau. We're pleased to be able to offer this webinar today. We think it's of great relevancy right now with all the oil and gas activity here in Texas and elsewhere in the country. I'd like to start with our first presenter. Steve Small is recognized as the nation's leading authority on private land protection options and strategies. As the former in-house IRS attorney, Steve wrote the regulations governing, or helped to write the regulations governing conservation easements, and is a very well-respected and well-known authority on these issues. Steve is going to start with an overview of the code, and then we will turn the presentation over to Joseph Fitzsimmons. So I'd like to turn it over to Steve now.
Thanks very much, Blair, and thanks to TALT for sponsoring this program. Very important program. We hope to give you at least some answers by the time we're done. I'm assuming that everybody on the call has at least a basic familiarity with Section 170H of the tax code. That's the section that allows you a deduction for donating a conservation easement. We won't go through all the conservation purposes tests. The bottom line of Section 170H is that you get an income tax deduction for protecting in perpetuity some important conservation values, wildlife habitat, open space, and so forth. For today's presentation, really the central provision is H5A. A contribution shall not be treated as exclusively for conservation purposes unless the conservation purpose is protected in perpetuity. Example, Aunt Sally has a farm It's a beautiful farm. It's 200 acres. It's prime agricultural soil. It's in a growing area with a lot of development. You can see the farm, and across the farm as you drive down the county road. Aunt Sally's Inn qualifies under 170H if she puts a conservation easement on that farm. However, if the conservation easement reserves the right to create and sell 20 10-acre house lots on the farm, Aunt Sally's out. The rights that she's reserved under the conservation easement, when exercised, will destroy any conservation values that might exist on that farm. The important thing to keep in mind when we're dealing with oil and gas and mineral issues is the same principle. Start with the proposition that you have a ranch or a farm or whatever the nature of the property, qualify under 170H. It has significant conservation values. But if you, as the owner, don't own all the rights associated with that land, including mineral rights, including the right to oil and gas exploration, Joseph will talk a little bit more about exactly what those rights mean, and somebody else, a third party, has the right to come in and tear up the ground, either in exploration, in the effort to explore for minerals or the effort to explore for and extract oil and gas, then you cannot guarantee, if those are the only facts, and they have the unfettered right to come in and do whatever they want, then you cannot guarantee that the conservation purposes are protected in perpetuity. So next slide, please. All right, there we go. One of the important rules, and it's a flat-out rule and there's no exception to it, is that if you want a deduction for a conservation easement donation, there cannot be, this is B little 1 there at the end of that section, there cannot be any extraction or removal of minerals by any surface mining method. No surface mining, period. If a third party owns mineral rights and has the right to come in under state law and extract minerals to the detriment of the landowner, then in order to qualify for a deduction, you really need a geologist's report that concludes, and this is the end of 2 little I special rule, that the probability of surface mining on such property is so remote as to be negligible. And we're not going to talk a lot about the geologist's report today, again, assuming that most of the people on the phone understand that concept. Bottom line, if you don't own all the mineral rights, you need a geologist's report that concludes that the likelihood of any surface mining is so remote as to be negligible. Next slide. And in fact, I think I can do that. Yeah, there we go. Qualified mineral interest, that's just a definitional term, not all that important in the discussion at this point. So we're going to skip over that and go to the next slide. Treasury regulations. This is more on the inconsistent use rule that I talked about a little bit before. 170H5 says you don't get a deduction unless the conservation purpose is protected in perpetuity. This says more or less the same thing. A deduction won't be allowed for the preservation of open space if the terms of the easement permit a degree of intrusion or future development that would interfere with the essential scenic quality of the land or with the governmental conservation policy that's furthered by the donation. Simple, speaks for itself, whether it's Aunt Sally allowing 20 10-acre house lots on her farm, or whether it's the ability of the owner of oil and gas rights or other mineral rights to come in and tear up the surface of the property unrestricted, no deduction. Next page, please. This is all, by the way, for those of you who are involved in this field, if you have not read the code and the regulations, then you need to do that. I think we can skip this one and go to the next slide, but again, more from the Treasury regulations. Qualified mineral interest. Most of this we can skip over, but I want to point out the last couple of sentences, beginning with however, about 2/3 of the way down that section. This is the provision in the regulations that was essentially copied from language in the committee report on 170H when it became law in 1980. that it really allows oil and gas exploration and a conservation easement. A deduction, however, a deduction under this section will not be denied in the case of certain methods of mining that may have limited localized impact on the real property but are not irremediably destructive of significant conservation interest. For example, the reg continues, a deduction will not be denied in a case where production facilities are concealed or compatible with existing topography and landscape, and when surface alteration is to be restored to its original state. So that's fine. What that tells us is it is possible to have limited oil and gas exploration and still qualify for a conservation easement. And that's very important to keep in mind. No surface mineral extraction, period. If you don't have the right to stop that, if someone else owns those rights, you can't qualify under 170H. But if you own all the oil and gas rights or somebody else does, and the exercise of those rights can be limited, then you could qualify under Section 170H. Next slide, please. And this is more, as soon as it comes up, on the qualified mineral interest rule. Where's that next slide? Okay. And this talks about the geologist's report and how the geologist makes the determination about surface mining. Again, less important for what we're getting at here today. Next slide, please. Summary of the rules right here. Number one, no surface mineral extraction. Number two, the conservation values need to be protected in perpetuity. Number three, there can be limited oil and gas exploration and extraction in certain circumstances as long as the conservation values of the property are protected. Now let's get to the next slide with a little bit more on how you figure that out, how you qualify, and what this all means. The first question, and when I do my CLE and other workshops, I always say fundamental practice tip, first question, first issue, run the title. Who owns the resource? And whether it's minerals, whether it's oil and gas, whether it's coal bed methane, whatever it might be, does the landowner own it? If the landowner owns all of it, it makes it a lot easier. Does a third party own it? If a third party owns it, it makes it tougher. Not impossible, maybe impossible, but definitely tougher. Are mineral rights leased? Oil and gas leased? Are there existing SUAs, surface use agreements? Joseph will talk about that. Is it just a royalty interest that pays the owner a % of whatever's extracted, which may not allow the owner of that interest to force extraction, so that could be okay? Is it an ownership interest, and so forth? And Joseph will get into those details a little bit more. The issue is protecting the conservation values of the property versus the potential consequences of oil and gas activity. And if you own, as a landowner, all the oil and gas rights, or if a third party owns all the oil and gas rights, to qualify for an income tax deduction, there has to be some limitation on the exercise of those rights. How much? Not clear yet, but we'll give you some tips on that. Okay, next slide. Landowner owns the resource. This is the easiest one. Landowner owns all the rights. None of the rights have been severed. You can't have any surface mineral extraction. How limited will the exploration and extraction of oil and gas or coal bed methane or whatever it might have to be, how limited does that have to be to qualify? We have no law on this. We're trying to create some good law and help people build a record. One possible analogy that I've used is if Aunt Sally, who's got a 200-acre farm, wants to reserve the right to have, say, 3 or 4 more house sites on the property, depending on where those are and depending on the degree of disturbance and depending upon the interference with the conservation values, she might be able to do that. You might be able to analogize to 3 or 4 drilling sites, but it depends. It depends on the characteristics of the property. It depends on where the resource is. Next slide. Third party owns the resource. Landowner wants deduction. Much more difficult. Again, minerals up or down. If you can get a geologist's report that says the likelihood of surface mineral extraction is soil motives to be negligible, that takes care of that issue. Oil and gas, it becomes much more complicated. Are there any outstanding leases? Are there any outstanding surface use agreements? What do they say? Do they allow the landowner some control over exploration that would protect the conservation values? Next slide. Building the record. It is clear that if you have a ranch and there are current oil and gas exploration activities and extraction activities on the ranch, and there is wildlife habitat on the ranch, let's start from the proposition that the oil and gas activity is not incompatible with habitat. And building the record, if you have a situation like that, or if there's one in your neighborhood or in your county or in your area, we really have to get into facts and science. You need the flora and fauna people to take a look at the property and say, here's the wildlife corridor, here's the wildlife habitat, here's the flora and fauna. Build a scientific basis to support your position that limited oil and gas exploration is okay. Where is the resource? If it's a big enough property, part of the property may lend itself to fairly heavy exploration and extraction. A significant part of the property might not. So you need to get into the specifics, and you need scientific help on that. And all of this gets merged into the baseline documentation report. It, excuse me, it doesn't say that anywhere out there in any written literature, but this is what we've learned. Joseph and I have worked on a couple of projects, and we've concluded that the best way to show the record that habitat can be compatible with oil and gas activities is to hire the right experts and to merge all that information into the baseline documentation report. My last slide, next slide, that really sums up what I've been saying and what 170H leads you to. Here are the issues and here are the questions. Who owns the resource? What's the nature of the interest? Does any of it actually exist on or under the property? And if so, where? And so there's a lot of science here and there's a lot of law here so far. Are there particular habitat locations or other important conservation values on the property? And if so, where? I remember in one of my first big conservation easement cases on a 3,000 or 4,000 acre property, the land trust on the other side said, no, you can't do any of that on this property. And I said, no, we can't do any of that on certain areas of this property. You show me where the most sensitive areas are, and we can do that, whatever it was on the balance of the property. Are there existing leases or surface use agreements? What do they say? Joseph's going to talk about state law, Texas law, but it's true in any state. In some situations, the holder of those rights, a third-party holder of those rights, cannot always exercise them to the detriment of the landowner and to the detriment of the conservation values. Does the landowner have any control over the degree of exploration or extraction under the existing documents and under state law? And finally, if the landowner does not own the resource, can the landowner control the degree of intrusion, degree of exploration, degree of extraction in a way that protects the conservation values of the property? Sometimes the answer to that is no. You can't do it, you can't control it, you can't qualify for a deduction. Sometimes the answer to that is yes. I'm done. Joseph?
Thank you, Steve. This is Blair. Let me jump in here real quickly. I'd like to remind our listeners that while the presenters are speaking, you may submit questions. There's a questions pane on the left-hand side of your screen. You can type in a question. We'll be collecting the questions and answering them. Our speakers will be answering them at the end of the session. Next presenter is Joseph Fitzsimmons with the Law Office of Uhl, Fitzsimmons and Jewett in San Antonio. Joseph is a natural resources, oil and gas and water law attorney and a third-generation South Texas rancher. You see his bio there. He has had experience with conservation easements not only representing clients, but also personally when he placed a conservation easement on his ranch in 2009. So I'd like to turn it over to Joseph.
Thank you, Blair, and thank you, Steve, for that excellent review of the tax considerations and conservation easements and mineral development. I want to get straight into the issue of mineral leases and conservation easements. Steve did an excellent job of summarizing what I'll call the opportunity given by 170H to recognize that a deduction under that section won't be denied in the case of certain methods of mining and mineral development. And for those of you in Texas, I'm sure you're familiar with the concept of oil and gas leases, but let me start with a basic definition so that people understand really what we're talking about when we talk about the potential conflict between a conservation easement and an oil and gas lease. What is an oil and gas lease? It's a legal agreement. It is unlike most legal agreements in that it is both a conveyance and a contract. It's an actual conveyance by the mineral owner to the lessee in what lawyers call a fee simple determinable, which means that oil and gas is conveyed in place subject to production. And so what this means is in this contract, this conveyance, you have certain conditions. And if you have in that contract conditions that relate to the preservation, conservation, management of the surface that is burdened by that oil and gas lease, then you have the beginnings of the tools you need to satisfy 170H, retention of qualified mineral interests. In the absence of any express provisions in an oil and gas lease or the original severance of minerals from the surface, or a surface use agreement attached to that oil and gas lease, the surface rights of the mineral lessee or mineral owner will be governed by common law doctrines. That's a long way of saying if you don't have any protections in the original severance, the lease, or surface use agreement, your only protection as the surface owner, conservation easement, donor, is the common law doctrines. Let's go to the next slide here. Those common law doctrines, the most important is the dominant estate doctrine. And as I often say in these presentations, dominant means exactly what it says. Some people have trouble understanding why the mineral estate, a severed mineral estate, is dominant to the surface. The simple reason is if you think about the nature of a severed mineral interest is that it no longer is part of the surface. And if that mineral estate owner cannot reach their property, then it's of no value. So it really makes sense that the mineral estate owner has this implied right or implied easement to enter the property, use as much of the surface of the property as is necessary to exploit that mineral estate. Now that's old, well-established case law. But the important thing to remember is the reasonableness and the amount of the use of that property can be restricted by the terms of the original severance or by the terms of the oil and gas lease and attendant surface use agreement. I stuck in a little passage in there on water usage. Water usage is becoming more and more of an issue in the development of unconventional oil and gas resources and shale resources, referred to as resource plays, because of hydraulic fracking and the potential conflict of water use between the mineral estate and the surface estate. Again, absent some agreement or limitation in the original severance, lease, or surface use agreement, the lessee is going to have the right to use water both from wells and surface water. There's a famous case, Sunoil versus Whitaker, which I use to illustrate the point to those who do not believe it's a serious issue. It is, especially in times of drought. You will see that conflict. So it's very important in your surface use agreements to address the water issue. In most of mine, I put all the control in the surface owner and do not convey any right to water use to the mineral lessee. So that sounds pretty severe, the dominant estate doctrine. However, we have something recognized in most states, but really the seminal case came from Texas, known as the accommodation doctrine. And like the dominant estate doctrine, which means what it says, accommodation means what it says, and that is that the holder of that dominant estate, mineral estate, must accommodate the use of the surface by the current surface owner. It was, I like to talk about the facts of the Getty case, which set forth this doctrine, and because it is, as is rarely the case in cases that make it to the Supreme Court, reasonable in the sense that the action that was being accommodated by the oil company is that you had a situation with a irrigation, a typical irrigation pivot. The Getty Oil Company wanted to put a pump jack in the middle of that field, and what the Supreme Court said was it was reasonable for that mineral owner to bury the pump jack far enough in a cellar by simply digging several feet in the ground to accommodate the passage of that irrigation over the top of the pump jack. So it's an excellent example of a relatively small accommodation that a mineral owner would make to make the use by the surface owner work. So you have then the accommodation doctrine as the only mitigation, really, to the dominant estate doctrine, absent anything to the contrary. And to the contrary, I mean you've got surface use agreements and restrictive language in the original severance. Next slide, 25, I think it is. Yeah, and we've had a little technical problem here with the slides, but you should be on slide 25. The mineral lease condition. There is a little twist to the accommodation doctrine that is worth noting. The original concept was that the use to be accommodated would be the current use of the surface by the surface owner. Some recent case law in Texas, in particular the Valence cases, are suggesting that that future uses must be accommodated where there is, and you'll see it slide 25, where there is a clear plan, not just intent and rhetoric, but an actionable plan to use that surface in that current use that then conflicts with a mineral owner's use. Let me give you a good example. In the Valence case, actually, it was a conflict between not a conservation easement, but surface mining and oil and gas development. But what they said was they had a clear plan to use this area that the oil and gas developer wanted to drill a well in. They had a clear plan to go and use that later for their surface operations. Well, you can analogize that to a conservation landowner who has a plan to develop wetlands for waterfowl or for some other purpose, and can show a tract that will be part of that master plan. The oil company comes in later and says, we want to permit a well there. Well, if you follow the logic in Valence, the surface owner, conservation landowner would be able to argue, no, you must accommodate my future use under the Valence case. So enough about that, but that is good news that we seem to have some developing case law that accommodates not only current use but future use. All right, moving on to the next slide here, 26. The very important to understand, as Steve pointed out, what are minerals are owned and by whom, and that will determine whether or not you satisfy that threshold question of being able to control or limit access to the surface for mineral development. One of the big issues, as pointed out by Steve earlier, is surface mining, and whether or not surface minerals are included in that original severance or lease under the definition of oil, gas, and other minerals. This is an area of law that is certainly deep enough for its own one-hour presentation, but let me make it very clear. It's either a surface destruction test, depending on when your severance was made, or the ordinary and natural meaning test. The surface destruction test for mineral estates severed from the surface prior to June 8th, 1983, write down that number, or that date, June 8th, 1983. If your severance is previous to that, then the surface destruction test will apply. That simply, again, means what it says. If the extraction of the mineral in question would destroy the surface, it is necessarily owned by the surface owner, and then of course that grantor or surface owner could subordinate or prohibit that as part of their conservation easement, or get the letter referred to by Steve. Moving on to the next slide, 27. If it is after June 8th, 1983, your severance, we'll use the ordinary and natural meaning test, which some commentators have said is neither ordinary nor natural, but it essentially means what is understood by those terms. Real quickly, there are some minerals that are considered minerals or surface as a matter of law. Uranium is a mineral as a matter of law. That last bullet point, at least in Texas, sand, gravel, building stone, etc., are the surface owners as a matter of law. Next slide. Let's do a quick review then. You've got, if the minerals are severed prior to June 8th, 83, you go with the surface destruction test. After June 8th, 83, the ordinary and natural meaning test. So at that point, you should know do I or do I not, as surface owner, control surface mining? In the next slide, we'll start running through some quick scenarios that should make sense to those of you who are asking, well, what about my situation? First scenario is very simple. The grantor, the landowner, owns the minerals, and the minerals are not leased, sometimes referred to as a unitary owner. So the grantor there can simply subordinate their mineral interest, which is unsevered, to the conservation easement. They can subordinate it by prohibiting any mineral development at all, or, as would be more practical, to require that any development be subject to the conservation values and conservation purpose of the easement, and putting in what I call a preemptive surface use agreement that obligates by contract the owner of the minerals or a future lessee to do that. You could then enter an oil and gas lease with those surface use protections that satisfy the protection of the conservation purpose. In the next slide, we'll look at something, scenario 2 is a little more complicated, where the grantor owns minerals and the minerals are already leased to a third party. At that point, you've got to look to the oil and gas lease for some specific surface protections. You are essentially dealing with the situation as you find it, and if there are no specific surface protections, you only have the common law protections we discussed, and at that point you've got to negotiate, request some subordination of the lease to the conservation purposes, or negotiate a surface use agreement that protects those interests. Next slide, we get to the third scenario where the grantor doesn't own minerals and the minerals are not leased, and control of that surface mining's got to be determined as to whether or not that surface owner can or cannot control surface mining. Then the deductibility of donation will depend on who controls surface mining and protection of conservation values through a surface use agreement. So if the grantor controls the surface mining and has a surface use agreement, there's less risk. If the mineral estate owner controls surface mining and there's no surface use agreement for other mineral development, then there's much greater risk, and you're back to trying to negotiate what you can. Next, scenario 4, where the grantor does not own minerals and the minerals are leased to a third party, you've got to look to the oil and gas lease for specific surface protections. If there are none, you only have the common law protections. And with that, I'll very quickly get to the last slide here because I know I'm running over time here. I just want to show you practically what recent development looks like, because we are living in a world where there seems to be added interest not only in conservation but in development. And there's a drilling pad in the Eagleford. You see a lot of very nice wildlife habitat around it. Go to the next slide, and you will see what that looks like afterwards. Very nice reclamation, a large lake there, which will then later be reclaimed, and the movement or development is on to the next pad, as you see it being done in a nice line that will all be recovered, as this one is, one of those pads, being restored, as the code says, to its original condition. And in the next slide, you will see that if it rains, this can actually happen. Next slide will show you that actual reclamation of a site. And the last shot is one of those locations after I'm sorry, that's a preparation of a location, and then the last slide shows the reclamation after about a 3-year period, and just to show you it can be done. So with that, Blair, I'll turn it back to you.
Good, thank you, Joseph. We've got a number of questions here, and I will direct these to either of you and jump in and answer them. Before I do, I'd like to point out that we do have a list of resources here. You see on your screen, these are different resources that Joseph and Steve have recommended, some advanced cutting-edge work in this area, so further reading for you all. So first question, this is for Joseph. Could you provide us with an example of substantial interference with a pre-existing surface use?
I'm sorry, Blair, you have to repeat that. I couldn't hear you.
Would you provide us with an example of substantial interference with a pre-existing surface use?
Substantial, I'm going to assume that pre-existing use is conservation related or open space related. So let's say that you have been operating your ranch pursuant to a Texas Parks and Wildlife management plan consistent with harvest recommendations, and that those harvest recommendations require you to do certain conservation practices, and the oil and gas company says we're going to go develop right in the heart of that specific habitat where you're doing that work and put all our facilities there and all of our tank batteries. Well, if you have a good a good surface use agreement, will give the landowner the right to direct the location of those facilities and protect that pre-existing use or conservation purpose.
The next question, if you own a partial interest of minerals, 50%, and 100% of the surface, how do you go about negotiating a conservation easement? Who would like to, Joseph?
Steve, you want to take a shot at that?
My first answer would be, and I think, again, you'd go to state law on this first, but my first answer is it doesn't matter how much of the mineral interest you own. If you don't own all of it and somebody else has a piece of it, an undivided interest, then they've got to come to the table. The deal has to be negotiated in such a way that they agree to whatever limitations you have on the conservation easement. Because it's my understanding that in every state, the owner of an undivided interest in minerals or oil and gas has the right to go in and explore. They may have to bear all the upfront costs and account to their co-owners, but they still have to be dealt with.
Well, I would agree to Steve's comment there that it's what we call co-tenancy, and under the law of co-tenancy, that other 50% has a right to go make an oil and gas lease, completely, if they have the executive rights, assuming, completely independent of that surface owner with the remaining 50%. However, most oil and gas companies are going to come and try and work something out with the surface owner to avoid conflict. But I just want to remind you, go back, as I said, go back to the beginning and read the original severance or lease. I'm surprised, now and then I find severances 50, 75 years old that give protections and control to the current surface owner in that original severance. So there's no substitute for reading the documents.
And in fact, let me jump in and add that everybody knows this already, but I can't emphasize it too much, that every single case that we're talking about, or potential conservation easement case, is very property specific, it's conservation value specific, it's state law specific, it's proposed use specific, and it's document specific if there are pre-existing documents. And if you're the owner and you own all the rights, then you hold the upper hand in negotiating. And if you want to donate a conservation easement and still reserve the right to do some exploration, non-surface exploration, it has to be limited, but you can do that. You've got all those rights. If a third party owns those rights, obviously you have to find out what the documents say and what their rights are. And if they're a pure capitalist, they may not agree to subordinate or limit their rights at all, and you may be done. On the other hand, again, it depends. It depends on what the resource is and how much there is and what the conservation values are.
Next question, how do executive rights play into these deals? Can you further define executive rights?
I guess that one's for me. Oil and gas real property law recognizes that the mineral estate has different components. One of those components, for instance, is the right to receive royalty. You can separate that from all the others. You can separate the executive rights. In other words, I can have the right 100% of the executive rights and only 50% of the royalty under my property. What the executive right means is you have the exclusive right to negotiate and execute an oil and gas lease. Obviously, that's very important to a surface owner. So I know a lot of these concepts are maybe new to some people, but probably the simplest way to look at this, and Steve and I have done this presentation live and come to the same conclusion, it's a matter of relative control. The more control a surface owner has over what happens or how the mineral estate is developed, the easier it is to make it compatible with a conservation easement. Or, said another way, to protect those conservation purposes in perpetuity. The less control the surface owner has, the less likely it is you can make them compatible.
And I would certainly second that, but I would also point out or repeat what I said earlier, that it's very important to build the record property-specific habitat on your property and so forth. That's point number one. Point number two, if it wasn't clear earlier, there is no clear law on this. And so we have to do the best we can to err on the side of being conservative. If you're a landowner and you want a deduction, you don't want to end up with a fully enforceable conservation easement that's determined not to meet the requirements of the tax code, so you lose the deduction and the property is still restricted. But we have plenty of experience with drafting conservation easements that protect conservation values, and I think we just need to import that over into this area.
Next question. What if one of the owners or lessee cannot be located or determined?
Well, this is Joseph. That depends if that person, that owner, has executive rights. I mentioned earlier that you can divide these interests into several different components or sticks in the bundle, as we say. So let's say that owner is only a non-participating royalty interest or a non-executive mineral interest. Either one of those interests has no executive rights. That's not going to be the issue for the surface owner. The surface owner, in the example given, has surface and it sounds like severed minerals or minerals already under lease. Future leases, the amendment of existing leases will be controlled by the owner of the executive rights. So it is unlikely you can't find the executive right holder. But if that's the case, you need a good title lawyer, because that has to be addressed.
I would add, again, it depends. We have a lot of experience in the Intermountain West, for example, where mineral interests have been separated from most properties, especially ranches, for sometimes more than 100 years. And they've been divided up and divided up and divided up and so forth, and there are owners of tiny little fractional interests out there and unlocatable. But I think, and again, this is an issue you'd need counsel versed in state law. It strikes me that if there's an owner of a 1/64th interest, it's a pretty safe bet that that individual is not going to come in and pay all the upfront costs to explore for anything if they're only entitled to 1/64th of the profits. So I think that's an interesting question, and again, depends on the percentage of outstanding ownership that you can't find, but I suspect there are ways to deal with that. And again, that's also part of building the record. I'd get an opinion letter from counsel pretty much along the lines of what I said, if in fact those are the facts.
Good. I have a related question here. What about conservation easements over lands where the ownership of the minerals varies? Some areas the mineral rights are not severed, and other portions the rights are severed. Can the easement be done over the whole ranch, or does it need to follow the mineral rights?
Let me start that. And again, I think it depends. We've been in some situations where we simply have not been able to encumber the entire property because of outstanding rights, and sometimes you've just got to cut it up. So in other words, the issue is how much, again, can you control the exercise of those outstanding mineral interests. One example that I could give that's analogous might be, well, not completely analogous, but under the case law in this area and the statute, there can't be any surface mining. So if you're dealing with a ranch that has gravel pits or caliche pits and they're active digging operations, one of the things we've done in the past is to encumber those, and this is where the landowner owns those rights, encumber those with clearly non-deductible conservation easements. You can continue to extract whatever it is you're extracting from the ground, and in the end you've got to reclaim and fix the property up, but you can't do anything else with it. You can't build a hotel and resort there. It's got to be dedicated to ranching and agriculture or farming or open space or whatever the purposes of the easement might be, and then encumber the balance of the property with the deductible conservation easements where there isn't any surface extraction permitted. So again, in some cases you can't do the whole thing. You've just got to do the best you can.
All right, we have time for probably one more question. I've received a lot of questions here, and I want to let the audience know that these questions and answers will be posted to our website. So if yours didn't get answered today, we will try to have it up there on our website soon. Last question. This probably goes to Steve. How can a landowner with a conservation easement protect against or stop an oil company from using eminent domain to establish a pipeline easement across the land? Doesn't this ruin the purpose of a conservation easement to preserve the land?
Great question. That's a whole other seminar. One of the most controversial issues in the field, the land conservation field today, is eminent domain by utility companies. And there isn't a lot of law on this that favors the landowner, but some land trusts around the country, including, for example, Piedmont Environmental Council in Virginia, has done a lot of work on the underlying issue how do you deal with utility condemnations? And the short answer to the question that I've gotten from people who've done this work is it's political. There isn't a legal way yet to stop something like this happening, and you've got to make sure that the political people and the regulators are educated and understand what the issues are, so that when they're confronted with condemnation of property subject to a conservation easement, they can look for other possible locations for the intrusion. Again, there's no simple answer to that, but in the East, where these are live issues as they are in other parts of the country, again, education of the regulators up front now, before the crisis starts, is a good idea. And one more comment in that regard. Again, the list of resources that was in your material and that Blair had up earlier. If you haven't dealt with these questions before, others have. And so you're not really starting from scratch. For example, the Colorado Coalition of Land Trust Mineral Handbook and their information has got a lot of useful information. And there is other good information out there by public interest groups on dealing with these issues. So you don't have to reinvent the wheel completely, only a little bit.
Steve, I want to add on that resources page that there's some great examples there of new technologies that are developed to mitigate and lessen the impact of drilling in open space, and are consistent with the language of the code in minimizing that impact. And one good example is lateral drilling or horizontal drilling. We've worked on some projects where we've been able to completely conserve and have no entry whatsoever in large, very large blocks, in some cases exceeding 1,000 acres, where all the development is done off-site or on the perimeters of the property, and the minerals are exploited through lateral that are, in some cases, a mile long. So the good news is the technology and the desire by both the business community and the landowners to mitigate the impact is consistent with conservation.
Well, I'd like to thank everybody for joining us today. We are out of time with that. I'd like to remind you that our slides and the webinar itself, the recorded webinar, will be on the Texas Ag Land Trust website. Within 48 hours, you will receive an email with a link to the website so that you can access the materials. And feel free to email us with any questions. You have the resource page for contact information for Joseph and Steve in the slides, and I'd like to thank you for joining us today.